Judgment in the matter of Secretary of State for Justice versus MM.
Under the Mental Health Act 1983, an offender who suffers from mental disorder may be sent to hospital under an order to which special restrictions may be attached if they are necessary to protect the public from serious harm. Such patients can be detained indefinitely and can only be discharged from hospital by the Secretary of State for Justice or a tribunal. A discharge may be on conditions, usually that the patient live in a particular place and be subject to both medical and social supervision. A conditional discharge also means that the patient can be recalled to hospital by the Secretary of State. The question in this case is whether, if the patient consents, the conditions can be so stringent as to deprive the patient of his liberty within the meaning of Article 5 of the European Convention on Human Rights, which protects the right to liberty. This patient suffers from mild learning disabilities, autistic spectrum disorder, and pathological fire setting. He was convicted of arson in 2001 at the age of 17, and a restriction order was imposed. He has been detained in hospital for all but 4 months ever since. He has applied to the tribunal for a conditional discharge. He is prepared to agree to a care plan which will require him to live at a particular place, which he would not be free to leave, and from which he would not be allowed out without an escort. In short, the conditions would amount to depriving him of his liberty. The First Tier Tribunal held that it did not have power to do this. The Upper Tribunal held that it did, but the Court of Appeal held that it did not. The patient now appeals to this court. Understandably, he would prefer to be out of hospital, even under those conditions, rather than to remain where he is. And he argues that this would be consistent with the Act's purpose of promoting his rehabilitation in the community for this to happen. The Act does not say anything about what conditions may be imposed. However, depriving a person of his liberty is an interference with one of his most fundamental rights. It is a general principle of law that such an interference has to be expressly authorised by Parliament in clear language. There is no such language here. Indeed, such a power would be contrary to the whole scheme of the Act. This provides in detail for the circumstances in which patients may be detained in hospital or a place of safety, who has power to take them there, who has power to detain them there, who has power to recapture them if they go absent without leave, and what treatment they may be given there. There are no equivalent provisions in relation to a conditionally discharged restricted patient. He cannot be given medical treatment without his consent. This patient could always withdraw his consent to the care plan and demand to be released. The only deterrent would be the power of the Secretary of State to recall him to hospital. It is understood, of course, that the purpose of a conditional discharge is to enable the gradual relaxation in the conditions of a patient's detention, so that he may be tested out in conditions of ever greater freedom and eventually be enabled to live safely in the community. Lord Hughes, dissenting, considers that the Act does not prohibit this. However, the majority of this court conclude, in agreement with the Court of Appeal, that, for the reasons already stated, there is no power to impose such conditions. Therefore, the appeal must be dismissed. The court will now adjourn.